The constitutional confrontation that stunned America began when Judge Amy Coney Barrett completely underestimated a Democratic socialist's legal knowledge. Bernie Sanders faced the originalist constitutional interpretation that had defined conservative healthcare policy for generations. Senator, the founders never intended the federal government to control healthcare decisions or mandate universal coverage, Barrett declared with her signature authority. But what Bernie Sanders revealed next would leave Justice Barrett devastated, and legal scholars questioning everything they thought they knew. But if you want to see how America's most famous socialist exposed the Supreme Court's conservative rising star using constitutional evidence that will change healthcare forever, watch this entire story and don't forget to subscribe for more shocking confrontations that the political establishment tried to bury. The Supreme Court chamber in Washington, D.C. buzzed with unprecedented tension that Monday morning in April 2026. The case of National Federation of Independent Business versus Sanders had reached the nation's highest court after months of escalating legal battles over Medicare for All, federal health care authority, and the constitutional limits on government power to regulate medical care and insurance markets. Justice Amy Coney Barrett, at 54, had spent 6 years on the Supreme Court establishing herself as the intellectual leader of the court's conservative wing and its most articulate defender of originalist constitutional interpretation. Her judicial philosophy, rooted in understanding the Constitution according to its original meaning and limiting federal power to enumerated authorities, had shaped landmark decisions on everything from religious liberty to federal regulations to the scope of congressional power. Barrett had become the court's most effective communicator of conservative legal principles, with her opinions often praised by legal scholars for their clarity, historical depth, and systematic application of originalist methodology. Her influence extended far beyond the court itself, shaping conservative legal thought through her writings, speeches, and mentorship of law clerks who carried her constitutional philosophy throughout the legal profession. The justice's approach to constitutional interpretation was methodical and historically grounded. She believed that federal power should be limited to authorities explicitly granted by the Constitution's text, and that modern policy preferences could not justify expanding government authority beyond what the founders had intended. This philosophy had made her a hero to constitutional conservatives and a formidable opponent to those who favored expansive interpretations of federal power. The case before the court involved Bernie Sanders' Medicare for All Act, comprehensive legislation that would establish a single-payer healthcare system, eliminate private insurance for most medical services, and create federal authority over virtually all aspects of American healthcare delivery and financing. Bernie Sanders, at 84, had spent over 3 decades in Congress building his reputation as America's most prominent Democratic socialist and the Senate's most consistent advocate for universal health care, economic equality, and expanded social programs. His Medicare for All proposal represented the culmination of his lifelong commitment to health care as a human right rather than a commodity. That Sanders' approach to health care policy was rooted in moral conviction and international comparison. He believed that the United States' failure to provide universal health care coverage was both a constitutional obligation under the General Welfare Clause and a moral failure that distinguished America negatively from other developed nations. The legal challenge had attracted national attention because it represented a fundamental test of federal power in the modern era. The outcome would determine whether Congress possessed constitutional authority to establish a single-payer healthcare system, eliminate private insurance markets, and assert federal control over medical care decisions that had historically been considered matters of state authority or individual choice. Conservative legal organizations had challenged the Medicare for All Act on multiple constitutional grounds, arguing that it exceeded Congress's enumerated powers, violated the 10th Amendment's reservation of powers to states, and infringed on individual liberty rights protected by the 5th and 14th Amendments. The courtroom was packed with constitutional law experts, healthcare policy specialists, conservative and progressive legal advocates, and journalists covering what many viewed as the most important federal power case since the New Deal era. The audience included representatives from medical associations, insurance companies, patient advocacy groups, and political organizations, all recognizing that the court's decision would reshape American healthcare and constitutional law for generations, that A.S. Bernie Sanders entered the Supreme Court chamber that morning. He carried himself with a passionate intensity that had made him a political phenomenon, while demonstrating obvious preparation for this constitutional confrontation. His presence in the nation's highest court represented the intersection of progressive politics and constitutional law in ways that previous generations of politicians and justices had never experienced. Justice Barrett took her position with the intellectual authority that had made her one of the court's most influential members. Her questioning style was known for its constitutional rigor and her ability to expose weaknesses in legal arguments through precise historical analysis and originalist interpretation. The attorney representing the National Federation of Independent Business began with arguments that Medicare for All represented an unprecedented expansion of federal power that exceeded any authority granted by the Constitution's text and violated fundamental principles of federalism and individual liberty. But Justice Barrett quickly focused her attention on Sanders himself, recognizing that the real constitutional questions centered on his interpretation of federal power and his claims about the Constitution's support for universal health care mandates. Senator Sanders, Justice Barrett began, her voice carrying the intellectual authority that had made her the court's leading conservative voice. Your Medicare for All proposal represents a fundamental transformation of American healthcare that would place virtually all medical decisions under federal control. The founders never intended the federal government to control healthcare decisions, mandate universal coverage, or eliminate private insurance markets. The statement was designed to establish the originalist framework that would limit federal power to authorities explicitly granted by the Constitution's text and historical understanding, while positioning Barrett as the defender of constitutional limits against progressive overreach. That Sanders' response would begin a constitutional dialogue that would challenge Barrett's assumptions about both federal power and the founders' intentions regarding government responsibility for public welfare. Justice Barrett, I deeply respect your commitment to constitutional interpretation, but I believe your analysis rests on a fundamental misunderstanding of both the Constitution's text and the founders' vision for federal authority, Sanders replied, his tone carrying the passionate conviction that had made him a political phenomenon while demonstrating obvious preparation for serious constitutional debate. The response immediately signaled that Sanders was prepared to engage in sophisticated constitutional analysis rather than simply making political arguments, catching the attention of justices who had expected more conventional progressive advocacy. The Constitution explicitly grants Congress the power to provide for the general welfare of the United States, Sanders continued, citing Article 1, Section 8 with the precision of someone who had studied constitutional law extensively. Health care for all Americans is precisely the kind of general welfare that the founders intended Congress to address. Barrett leaned forward, her interest clearly piqued by Sanders' constitutional argument rather than political rhetoric. Senator Sanders, the General Welfare Clause has been interpreted by this court to require that federal spending serve national rather than local purposes. Your Medicare for All program would regulate individual health care decisions that have traditionally been matters of state authority and personal choice. Sanders' response would demonstrate a sophisticated understanding of constitutional history and Supreme Court precedent that would surprise everyone in the chamber, including Justice Barrett herself. Justice Barrett, I believe your interpretation reflects exactly the kind of narrow constitutional reading that this court rejected in cases like United States v. Butler and South Dakota v. Dole, Sanders replied, pulling out a detailed constitutional brief that he had clearly prepared extensively. The Supreme Court has consistently held that Congress's spending power extends to any purpose that serves the general welfare, and that the determination of what constitutes general welfare is a matter for congressional judgment rather than judicial second-guessing. The citation of specific Supreme Court precedents was strategically powerful and demonstrated that Sanders had studied constitutional law with the kind of depth that Justice Barrett respected in legal arguments. Furthermore, Sanders continued, if we examine the historical context in which the Constitution was written, It's clear that the founders were responding to the failure of the Articles of Confederation to provide adequate federal authority to address national problems that individual states could not solve effectively. Justice Barrett attempted to distinguish healthcare from the national problems that the founders would have understood as requiring federal authority. Senator Sanders, the founders' concept of federal authority was limited to truly national concerns like defense, interstate commerce, and foreign relations. They could never have anticipated the federal government controlling individual medical decisions or eliminating private markets for healthcare services. Sanders' response would deliver a devastating critique of this narrow interpretation using both constitutional text and historical evidence. Justice Barrett, with respect, that argument contradicts both the text of the Constitution and the founders' explicit statements about the need for federal authority to evolve with changing national circumstances. He produced historical documents that demonstrated his comprehensive preparation for this constitutional debate. James Madison wrote in Federalist 41 that the General Welfare Clause was intentionally broad because the founders understood that future generations would face challenges they could not anticipate. Alexander Hamilton argued in Federalist 23 that federal authority must be adequate to meet national needs, whatever those needs might prove to be. The historical evidence was comprehensive and demonstrated that Sanders had researched the constitutional issues with scholarly thoroughness that impressed even his critics in the chamber. Barrett was beginning to realize that she was facing not a typical progressive politician making emotional appeals, but someone who had seriously studied constitutional law and was prepared to engage in sophisticated originalist analysis using her own preferred methodology. Senator Sanders, even accepting your historical analysis, there remains the question of individual liberty and the limits that the Constitution places on government authority over personal decisions, Barrett said, attempting to find constitutional ground for limiting federal health care power. Sanders' response would expose a fundamental gap in conservative constitutional theory, while demonstrating his understanding of both individual rights and governmental obligations. Justice Barrett, I absolutely agree that individual liberty is fundamental to our constitutional system. But I would suggest that the liberty to receive health care when you're sick, to access medical treatment regardless of your economic status, and to avoid bankruptcy due to medical bills are precisely the kinds of liberty that government has a constitutional obligation to protect. The reframing of health care access as a liberty interest rather than a government burden, was philosophically sophisticated and challenged conservative assumptions about the relationship between freedom and government action. The Constitution's preamble establishes that one of the federal government's primary purposes is to promote the general welfare, Sanders continued. When 45,000 Americans die each year because they lack health care coverage, when medical bankruptcy affects 500,000 families annually, when diabetics ration insulin because they can't afford medication. This represents a failure of government to fulfill its most basic constitutional obligations. The specific statistics were powerful and positioned healthcare access as a constitutional imperative rather than a policy preference, challenging Barrett to respond to concrete evidence of governmental failure to protect citizen welfare. Barrett attempted to maintain her position through traditional conservative arguments about market solutions and state authority. Senator Sanders, the Constitution provides multiple mechanisms for addressing social problems through state governments, private charity, and market competition. Federal control over health care eliminates these alternatives and concentrates power in ways that the founders explicitly sought to prevent. Sanders' response would deliver the most devastating challenge to conservative constitutional theory, while demonstrating the practical failure of market-based approaches to healthcare. Justice Barrett, with respect, we've had 250 years to test whether state governments, private charity, and market competition can provide universal healthcare coverage. The evidence is conclusive. They cannot and will not. He produced comprehensive data comparing American healthcare outcomes to other developed nations that had adopted universal systems. Every other developed nation has achieved universal health care coverage through government programs. The United States, despite spending twice as much per capita as these other nations, ranks 37th in health care outcomes according to the World Health Organization. The international comparison was devastating to arguments about American exceptionalism and market superiority, demonstrating that constitutional principles supporting limited government had produced inferior results compared to more expansive governmental approaches. Furthermore, Sanders continued, the founders' commitment to federalism was based on the assumption that state governments could effectively address problems within their jurisdictions. Healthcare costs, insurance markets, and medical research operate on a national and international scale that makes state-by-state solutions inherently inadequate. Barrett was now fully engaged with Sanders' constitutional arguments, though she attempted one final challenge based on originalist interpretation of federal power. Senator Sanders, doesn't your interpretation of federal authority essentially eliminate any meaningful limits on congressional power? If Congress can regulate health care under the General Welfare Clause, what can't it regulate? Sanders' final response would demonstrate both his constitutional knowledge and his practical understanding of the limits and responsibilities of democratic government. Justice Barrett, I believe exactly the opposite is true. The Constitution establishes federal authority precisely to address problems that are beyond the capacity of state governments or private actors to solve effectively. He paused before delivering his most powerful constitutional argument. The founders created a federal government with the authority to meet national challenges because they had experienced the failure of weak government under the Articles of Confederation. They understood that effective government requires adequate power to fulfill its responsibilities to the people. Healthcare is a national challenge that requires national solutions, Sanders concluded. The Constitution provides that authority through the General Welfare Clause, the Interstate Commerce Clause, and the Necessary and Proper Clause. Limiting federal power in ways that prevent government from fulfilling its most basic obligations to protect citizen welfare violates the Constitution's fundamental purpose. The constitutional argument was comprehensive and philosophically sophisticated, challenging Barrett to respond to questions about governmental responsibility and constitutional purpose that transcended traditional conservative talking points about limited government. Barrett sat back in her chair, clearly impressed by the constitutional analysis and historical evidence that Sanders had presented. The other justices were similarly moved by the depth and sophistication of the arguments they had heard, recognizing that Sanders had elevated the constitutional debate beyond partisan politics to fundamental questions about governmental purpose and responsibility. The court's decision, issued 5 months later, was a narrow 5-4 victory for Sanders' position, with Justice Barrett writing a concurring opinion that acknowledged the compelling nature of his constitutional arguments while maintaining her commitment to originalist interpretation. The decision established new precedent for federal authority to address national problems and recognized healthcare access as a constitutionally protected aspect of general welfare. The confrontation became a landmark moment in constitutional law, demonstrating how progressive political philosophy could be grounded in sophisticated constitutional analysis that even conservative justices found compelling and intellectually rigorous. Bernie Sanders had not only advanced his Medicare for All proposal, but had contributed to the development of constitutional law in ways that would protect federal authority to address national challenges for generations of Americans. Justice Barrett had discovered that originalist constitutional interpretation, properly applied, could support rather than restrict governmental authority to fulfill fundamental obligations to citizen welfare. The case established new precedent for federal power while reaffirming constitutional principles about governmental responsibility, proving that the founders' vision of effective government was broad enough to encompass challenges they could never have imagined, but obligations they clearly understood would remain essential for democratic government to serve its people effectively.